Now for what's tipping the scales in the newest trial we are tracking here at Court TV. The jealous ex shot dead trial is underway in Massachusetts. Defendant Brian Camp is charged with manslaughter for the death of Johnathan Letendre. This was his girlfriend's ex-boyfriend, and prosecutors say Letendre broke into that home that Camp shared with his girlfriend and their 2 kids and began attacking Camp in his sleep. Camp claims that he shot in self-defense. The first shot, the state agrees with him, says he was a victim and he was lawful in that shot. But it's the second shot to Letendre's head, approximately 8.5 minutes after the first shot, that shows Camp, according to the state, used excessive and unnecessary force. Here's more on the story from Court TV's crime and justice correspondent, Matt Johnson.
24-year-old Brian Camp is charged with manslaughter in the death of Johnathan Letendre.
He was 27 years old. He was the general manager for Dunkin' Donuts. And it was through his work at Dunkin' Donuts that he met a young woman named Brooke Janik. During a break in Brooke's relationship with Mr. Camp in early 2022, when they had split up, Mr. Letendre and Ms. Janik struck up a relationship.
Their relationship was brief. When she went back to Camp, Letendre did not take it well. And on December 27, 2022, Camp, Brooke, and their 2 children were sleeping at a home when Letendre broke in shortly after midnight. Brooke heard someone coming up the stairs and screamed.
And then before I even could see, because I just woke up, before I could even see, there was some guy standing in the doorway. Before you know it, the kid's on top of me. Mind you, I had no clothes on. I'm trying to wrestle this kid. I don't know, he was trying to dig my eyes out, telling me he was going to kill me.
Investigators say that there was a brutal fight. Brooke called 911, and on the audio of that call, a gunshot is heard. Then about 8.5 minutes later, she reacts to a second gunshot.
Okay, you just heard another gunshot?
Letendre was shot in the torso and in the back of the head. Prosecutors say the first shot to the torso was lawful and in self-defense. They claim the second shot was not, but the defense alleges Letendre was still able to move and still a threat.
Mr. Letendre was able to move, was moving, and that Mr. Camp, after all of this, believed that he needed to shoot again because he needed to stop this thing because it clearly was not stopping.
Camp pleaded not guilty.
Yeah, and I shot him because the entire time he'd been telling me he's going to kill me.
This is a unique trial, a unique case. Some are saying it shouldn't even be going to trial in the way that this incident went down. We're asking, do the state laws there in Massachusetts having to do with stand your ground, self-defense, the castle doctrine, do they tip the scales of justice? And we have a great panel to discuss this from 2 states that sometimes are on opposite ends of the spectrum. We have in Massachusetts, attorney and former homicide prosecutor Richard Grundy, and in Florida, we have civil rights attorney John Phillips with us. Richard, let me get your take on all things Massachusetts there and what you think about this case where the prosecution says, yes, self-defense for the first shot, but the second shot, manslaughter.
So that does, from what I've heard and listening to the open statement, lines up with the current law in Massachusetts, which does recognize the castle doctrine, that being Massachusetts has a duty to retreat, but that duty to retreat is negated if you are lawfully within your abode, apartment, house, whatever, protecting yourself or the others. So that aspect of it fits in with this prosecution only because the duty is that you're excused to use in these circumstances is only so much as to negate, quell the threat that is against you. And as we heard in the opening statements, this case is really about those 8 minutes after the first shot and prior to that second one, which, has been put forth by the prosecution as basically a kill shot of a person who was potentially mortally injured at that point in time. I was interested in listening to the openings that we didn't hear any discussion with respect to medical testimony as to exactly what life may or was not in the victim at the time the second shot was issued to his head. But it is there. I think it would be a difficult case in light of those 8 minutes and a shot to the head for the prosecution not to prosecute. They went with manslaughter, which is really a negligence standard, which is somewhat of an odd fit. But I think that what's notable is it takes it out of any kind of minimum mandatory sentencing. He is actually trying this to a jury and to a judge if he's found guilty, who will do that sentencing and could put him on probation.
You're raising a great point, Richard, about the deadliness of the second shot versus the first. We're going to talk about that more in a minute, and we are going to be seeing those opening statements in our next hour. But first, I want to get Attorney John Phillips's legal analysis of this case. And John, you know, because I was a reporter in the area where you are, I know many of your cases personally, having covered them, and you represented the victim's family of a case where the defendant claimed stand your ground, which in Florida always gets headlines. Talk about your take on this particular case where this was an ex who broke into their home while they were sleeping.
And you're right. And in that case, it took 2 trials to fully convict Michael Dunn of the murder of Jordan Davis. The first case was about an attempted murder. And what you're going to hear here throughout the defense case is need versus want. He needed to shoot him the first time, but he wanted to shoot him the second time, right? And that's where the medical testimony is really key to see how much damage the first shot did. But let's boil back to old common law England that we brought with us with the castle doctrine and self-defense. And a man or woman is at home in their castle and safe. There's no duty to retreat. You don't need to have someone flip from being an aggressor to a non-aggressor. I do think that's why they charge the lower level, but I think this is a state's case.
And Richard, I do think that from the openings we did learn that the prosecution says he was incapacitated with that first shot, that he was in the kitchen, and you have a defendant who took a phone call from his boss during that 8-minute period between the 2 shots, that he took a picture of the shooting victim in his home. I don't know how that will sit with a jury, perhaps just to show this happened, but they're going to say that he wasn't moving. Is it a problem, and perhaps it's a societal issue that the prosecution wants to make sure we don't condone, that you can't treat him like an animal, that if he's in pain, if he is not moving, or he's seemingly had a really terrible situation from the first shot, that we don't just put you down, which the prosecution says they heard the defendant say that. The officers are going to say they heard him say, if it were me, I would want someone to put me down.
Yeah, and I agree with you, Julia, and I think that's why I said I think that it's a tough case for the prosecution not to address, and they've left the door open for someone other than themselves to decide ultimately how it's addressed upon a conviction, that being the judge, and that being the judge having a range of from probation to 20 years incarcerated. I will say that I know Steve Gagne. I've worked a little with him over the years. I thought he did a very good job in the opening and really bifurcated these issues between the initial clearly self-defense of an individual being attacked and that second shot. I found it interesting that neither party got into this telephone call with the boss and any further with respect to the picture, because between what the medical examiner will say about the first shot and what that boss discussed with this individual, I think that will give us be a good barometer as to where on this. And I'm just kind of surprised we didn't hear more of in the openings.
Right, we should hear more soon. Real quick before we have to go to break, John Phillips, how do you think a jury is going to react to Jeremy Camp?
Oh, it's going to be a tough case. I'd rather have the civil case, I'll say that. But you know, I think the jury will convict.
And Brian Camp, I meant to say Brian Camp. John Phillips and Richard Grundy, thank you so much for being with us this hour, sharing your expertise.